all of you and have the opportunity with respect to legal advisors to talk to you about this very important subject of mediation, which, as you will see, has been very important not only in the United States and various portions of Europe, but in an increasing way throughout the world. What I'd like to do first is just briefly describe what our foundation is that is presenting this program, and my esteemed colleagues that are here that will be participating with you during the course of the day. The delegation that's coming today is actually called the Foundation for Sustainable Rule of Law Initiatives. It's a rather long title, but the idea is that our mission is to work when we're invited by a host country anywhere around the world to work with the judiciary, with the bar associations, and with the public to help these host countries establish a mediation program where there are backlogs of court cases that aren't getting heard for many years, and the cases that are backlogged can be referred to the mediation center in a very expeditious way to resolve these cases in a matter of hours or a few days, rather than have them languish for many years. So as part of that effort, we've been invited to come to Poland. We've met a number of your judges and a number of your esteemed colleagues and discuss with you our experience, and particularly now with regard to our group of legal advisors, what mediation is about, how these programs operate from the perspective of your practice. So first, let me introduce my colleagues. On my left is Claudia Bernard. Claudia has been in charge of our court mediation program and what we call our appellate level. She'll describe a little bit of that to you. For many years, she ran that program. She did mediations, and of course, she's taught mediation as well too, in addition to practicing law in this area. On my right is Howard Herman. Howard is also an active practitioner of mediation. He was responsible, as he will describe, for running a court-annexed mediation, a very successful program, as was Claudia's, a very successful program in our federal district court. So it's kind of our first instance court of litigation in the United States, which has become a very successful program throughout the country. A word about myself. I am, well, I like to say a recovering litigator, you know, like a recovering alcoholic. I've litigated for 50 years, enjoyed it, enjoyed the adversarial nature of it, but in my late couple of decades, was invited to participate in mediation court programs, loved the work of mediation, and since that time have been doing mediations and are running this foundation to promote mediation throughout the world. So the combination of all of us, as you can see, is meant to bring varying perspectives, but a lot of experience. And in my case, I want to reinforce having spent 50 years litigating these cases with a very high degree of success. When we speak about what's going on from a litigator's perspective or an adversarial perspective, it's not merely academic. It really reflects in the real world what we have learned about how mediation interfaces with what's going on in litigation. So that, by way of introduction, is who we are, our organization. And I think what we'd like to do is a quick survey of what we're going to do today with respect to an overview before we get immediately into the substance of our program. What I think I should do is perhaps just review the outline overall. First, we're going to have, Claudia is going to do a little bit of a survey of the audience, so we have a good feeling of what your level of knowledges, experiences, exposure is to the concept of mediation, so we can be sure that we address our comments to those things that are most important and relevant to you. We will then move to a section on the proper identification and selection of cases for mediation. What kinds of cases are appropriate and what might not be appropriate, and when is the appropriate time to use mediation. We'll then talk about the key elements to optimize a successful mediation process. What are the things that you look for to make sure if you participate with your clients as an adversary, as a counselor, What are the ways to make that process work successfully for you and your client? We'll talk thereafter about the qualities of a good mediator, the best ways to select a mediator. That's very important. There clearly are choices to make as the type of mediator that you want in terms of the personality, their mediation style, and all the other aspects that will make sure that it maximizes your opportunity for a successful experience. And then we'll also talk about effective advocacy skills. What is it to effectively advocate for your clients that you represent in the mediation? As we will describe, it is a very distinct, it's related, but it's a distinct and different skill than in the courtroom when you're litigating a case before a judge. Let me say that at each section, our plan, depending on how active you are in your questions, is to allow a brief question and answer period after each segment. So we hope, even though we're on Zoom, we hope that you will be, as you are in terms of your work as legal advisors, free to raise questions, because that helps us know what is most important to you rather than our guests based on what we have learned as to what might be most important to you. So there is a certain, if I can say, responsibility you have to help us through this Zoom process to make it all happen. So that's a quick overview about where we are, who we are, and what we plan to do during the course today. Let me now turn it over to my colleague, Claudia Bernard, who will take it from here.
Thank you, Vic. Good morning. So we did, as Victor said, we wanted to get a sense of who you are. So you will see some questions that should appear on your screen. And so the first question for you is, have you participated in a mediation as a legal advisor? So please answer yes or no on your screen. Or which is yes, which is no.
It's good. We're getting answers.
We're getting answers.
The question is, that question that's up there is in more than 10.
Oh, okay. So have you, well, fine. So 61%. Got it. Thank you. Have you participated in more than 10 mediations as, the questions are in the wrong order, I believe.
Right.
Well, let's just go with that.
Okay, right. So a few of you have participated as a mediator, most of you not. Okay, have you participated in a mediation as a legal advisor? Next question. Yeah, these are not working out well. Have you participated in a mediation as a legal advisor?
Thank you. We're getting the responses.
Oh, interesting. So a little more than half of you have. Let's say what that looks. Yeah.
About
55% of you have, and about 45% of you have not participated in a mediation as a legal advisor. Beautiful, very helpful. So for those of you who have participated in a mediation as a legal advisor, have you participated in more than 10 mediations as a legal advisor? Have you participated in more than 10 mediations as a legal advisor? No, but this is showing up as a mediator. Wrong question. Okay. Yeah, perfect. No,
So
okay.
mostly not.
So mostly not. This is so helpful. Thank you very much for answering the questions. So most of you have not participated. Most of you who have participated as a legal advisor in a mediation have not participated in more than 10 mediations. Thank you very much for answering our questions. It really gives us a much better sense of who you all are out there. So thanks.
Okay, back to me.
Yeah.
So the next subject that we'd like to get into is the proper identification and selection of cases of mediation. And about this subject, there's oftentimes a great deal of misunderstanding by people who have not been through the mediation process. The answer to the broader question, and by the way, my focus is going to be on civil matters, not criminal matters. Our emphasis today will be on civil matters. Although we welcome, if you have questions later on, you want to ask about the use of mediation in some kind of restorative justice context, at the end of the day, we'd be happy to answer those. But our focus today is dealing in the civil area. And simply stated, as a general rule, we very positively and assertively say just about every kind of case in the civil arena is appropriate for mediation, at least in terms of subject matter. That means, and certainly in my work and in our work, we have found that cases involving commercial matters, employment matters, property matters, all kinds of family disputes. In fact, we have found that throughout the world, and I think this is true in Poland as well, that most businesses are relatively small businesses rather than large corporations, and that these family business matters are a large category of cases, in addition to the large corporate cases that we see dealing with securities and merger acquisition and the like. So overall, at least in terms of subject matter, we are very bullish. We are very assertive and encouraging that just about every kind of case is appropriate for mediation, at least by way of subject matter. Now, we're not going to belabor this point. There's a little bit of controversy about dealing with some, if you will, public policy questions, tax matters, which are a major subject of litigation in many countries, whether these are appropriate. And those go more to the laws of the parliament of the respective countries that we deal with, and also whether or not individuals from these various entities, the public entities, can come with sufficient authority to engage in a genuine mediation process. But we're going to focus essentially on the vast majority of those cases by subject matter and content which are appropriate. I would say, in identifying the appropriate cases for mediation, there are some aspects that you want to consider. And in fact, we mention this to judges as well, too, when we give judges a bit of a guideline as to what cases are the kinds of cases where there's a judge referral system into the mediation center. We tell them to look for certain things. Is it a case in which the facts are generally quite clear and the pleadings are quite clear with respect to the legal allegations? Is it a situation where expert or other witnesses, if they are required, can be brought into the mediation process in order to bring about a successful result? Is it a case in which creative and multifaceted, many kinds of creative ways to solve the problem are available? And of course, as I already mentioned, does the case involve government or public policy or constitutional issues, which in many cases might not be appropriate, and in fact are most appropriately litigated because of their public policy aspect? Generally, those kinds of questions help mediators and help prospective participants in the mediation process understand if a case is suitable for mediation. But we are very expansive, as you'll hear all three of us say. The simple answer to the question is that essentially just about every subject matter except these very limited areas are appropriate for mediation. Now, mediators may require different skills. Obviously, the skills to deal with a highly emotional, contentious, toxic marital case may be very different than a buyer-seller breach of contract kind of action. A case for sexual harassment or sexual discrimination, which is usually very highly emotional, can be very different than a purchase agreement matter. On the other hand, as I'll talk about a little bit later on, dealing with intellectual property disputes, IP disputes, highly significant bet the company kinds of cases. In many such situations, the winner or loser gets to run a company that can be great in its profitability, and the loser in an intellectual property dispute, who can no longer license their work or participate because they don't have licensing rights, they can lose the very essence of their business. So all of these aspects have been submitted to, are participated within the mediation context very, very successfully, and are within the arena, the proper arena for mediation resolution. So with that in mind, let me ask you if there are any questions that you might have. We'll pause here just for a moment with respect to the suitability of the kinds of cases that might be submitted to mediation from your perspective as people that are involved in the business community. Are there questions that you might have with respect to what should be submitted to mediation, or if there are questions you have about their appropriateness? Anything come up at all? Nothing? Okay. We're going to pick on you a little bit more to get these questions out. We know that you are articulate, and we're going to continue to press on with our next subject, but hopefully you'll formulate any questions you have. And I would also add, if there's a question that in an earlier subject that we have now finished and gone to another subject that you want to raise, feel free to step back with us to an earlier area if you wish to do so that we can make sure to get to the questions that exist within the audience. With that in mind, let's move on.
Well, I have a couple of things I wanted to add about looking at what are the best cases for mediation. And I would suggest that oftentimes when you have a relationship that you want to preserve or you want to heal, that mediation is so effective in being able to do that. So if you have a case where you have two businesses who are fighting with each other, but they're maybe fighting over something that's relatively minor, and in the overall scheme of their business relationship, they would do better to heal the relationship, to solve this one little problem so they can go on doing business together. Mm-hmm. That's a kind of case that really, really cries out for mediation. And so if you look not so much at the subject matter of the dispute, but the relationship between the parties, that often can help guide you in figuring out whether this is a case you want to push for mediation. The other thing that I would emphasize, again, that it's not about the type of case, but is there a practical solution that the parties could reach that would solve the case that no court could impose, that would actually be easier and simpler? And when we were talking before, Vic had said, well, constitutional cases are cases that kind of categorically you can't mediate. And that is true. You cannot mediate a constitutional issue. But what you can mediate is the practical issue around it. So, for example, in the US, we have a very strict rule about separation of church and state. And what that means in practice is that you cannot have religious symbols on public property. And one of the kinds of constitutional cases that comes up for us rather frequently is when a city or a municipality erects some kind of Easter or Christmas display on their property. And the courts have held, if it's kind of secular, then it's okay. But if it gets too religious, then it's not okay. So I mediated a case like that where the plaintiffs thought it was too religious, this Christmas display. It didn't belong on public property. Well, there was a very simple solution, and that was we could move the display about 10 meters onto private property. It still was in a very similar place, still got a lot of public views, but it was no longer on public property. It satisfied the plaintiff, it satisfied the city, it satisfied the populace who wanted to be able to see this display. So if you think creatively about not the legal issues, but the practical issues, can there be a practical resolution to this? And can a mediator help the parties develop and create these practical resolutions to bigger legal issues and constitutional issues that couldn't be mediated? That's, in my mind, another kind of category of cases that you really might want to be looking at.
So if I could also add in, I think that as the legal advisor, when you're thinking about whether or not this is a case that's appropriate, if you see creative solutions, as Claudia was just talking about, that's great. That's a guide for a reason why you would want to go forward. But even if you can't think of creative solutions, it might still be appropriate for a mediation process. That creative solution, you may not be able to see it, but perhaps in the course of the mediation, it will come forth. So it's a guideline to tell you when you certainly should go forward actively thinking about mediation if there is a relationship or if there is a creative solution. But even in those situations where you as the legal advisor don't think that there's a possibility of creativity, you might still consider it as possible. I use as a guide sort of the following rubric. Mediation, by definition, is simply a facilitated negotiation process. So what that means is that anywhere where negotiation might be possible, it's also possible to negotiate with the help of a mediator. And that's part of, I think, the breadth of our approach, is to really think about, well, if there's any way that this could be subject to a negotiated resolution, we ought to be thinking about whether negotiating with a mediator involved is possible.
Okay.
Okay. So something has appeared on the screen,
Which we cannot.
which we can't understand.
Does that mean we're still on?
And I can't tell if we're still on. There's something on the screen that is a message that looks like there is a problem.
And I definitely is not in English.
Our Polish is not good enough.
There we go.
There we go.
Something's happening. That's promising.
We're good?
We're good?
All set?
All right.
We can proceed? Okay, good. All right.
Oh,
Maybe we should open.
Oh, I also just one other thing to say. In order for you to be able to help your client make the decision about whether mediation is appropriate, and we'll talk about this more later, but it really means that you have to know what's important to your client. You have to really know what their true business or personal interests are in the resolution of the dispute. And so it calls out for a very high level of understanding of what they need.
I'm sorry, but we have something else that's appearing on the screen, which is confusing to us. I apologize.
Just want to make sure we're not disconnected. Okay, we're back
Right.
on. All right.
With these comments, maybe we ought to ask again if there might be any questions about this topic before we move on.
Sure.
Let's try again, see if anybody has a question or a comment based on what we've said so far.
Are you out there?
No.
Nothing.
Okay.
All right.
So you want to move on?
Yes,
To,
let's do that. That really raises the issue of, how do we prepare appropriately for a mediation in the mediation process? And this is especially important, I think, dealing with your responsibilities as legal advisors, because the question of just walking in to a mediation and not having thought out the best way to represent your client and to achieve the goals that you think your client has is really lose the opportunity to optimize the possibility for some kind of success along those lines. So what we'd like to talk to you a little bit about here is what are some of the key elements that come into play in terms of bringing about a successful result in the mediation process. And let me turn over to Howard first, perhaps to hit on some of the points, and then we're going to amplify this together because I think what you're going to find is that some of the things that we're going to suggest might not be the normal way you would proceed here in Poland. And we hope you'll point out if it's not the case, and therefore we need to examine it more fully in a different perspective. But the things that Howard, Claudia, and I are going to talk to you about are the techniques that we have found not only in the United States, but in very different cultures in Asia and South America and Eastern Europe to be very helpful in bringing about a successful result. Howard, let me turn it over to you.
Thank you very much, Vic. So I want to just emphasize what Vic was saying last. What we can do here today is to share with you what has worked so well for us over, for me now, it's almost 40 years that I've been working as a mediator, and what we've seen in our practices, and we can share this with you, but we couldn't possibly know enough about Polish practice to tell you what to do. What we can do is share with you what has worked for us, what we've seen worked in other places, and then it'll be up to you to figure out how best to apply this in your own work. I want to go back to something I said a moment ago, which is that mediation itself is really just a facilitated negotiation. So the first premise for me in thinking about how to optimize the mediation process is to think about, well, what makes for a good negotiation? When you are working with your client to prepare for any kind of negotiation as their advisor, what are the things that you need to focus on in order to ensure that you're going to get the best possible outcomes of that negotiation process? And the first byword is preparation. You don't just walk in cold to a negotiation. You've really tried to think through, well, what is it that you're trying to achieve, and what are all the possibilities for that negotiation process? In our experience, often the mediation process, the mediation itself, might be the most important event, every bit as important as a trial might be. So it requires the same level of preparation that you would devote to an important trial, to an important appearance in court. So in thinking about negotiation, I think there are a couple of different aspects that are so important. The first has to do with just the monetary aspects of any negotiation process. You don't just come in not having thought through really where you want to end up. So the best mediations that I have experienced are ones where the legal advisors, the lawyers, and the client have really thought through, well, what is it they want to accomplish? What is their goal in the mediation? on a monetary basis. So what are they targeting for? And in light of that, really giving some thought to what kind of an opening move they're going to make makes sense, and some thought to what their bottom line is going to be. And in light of all those calculations, really thinking about how they're going to open and then how they're going to make concessions through the course of the negotiation process. But I want to say something about preparing and sort of drawing your bottom line out, because the best mediations are ones in which people come in with a sense of really what their last number is going to be if it's a monetary negotiation, but with some awareness that they may hear something, they may learn things during the course of the mediated conversation that allow their views to shift. So you want to have some thought to all your monetary positions in advance and to have really worked through that, but also coming with enough openness that things can shift during the course of the mediated negotiation conversation. But almost all negotiations that in mediation have an aspect that Claudia mentioned earlier, and that has to do with not just the dollars that might be exchanged between the parties in settlement of their dispute, but really focusing more broadly on what the real underlying needs and interests and concerns are for the client, not just looking at the dollars and cents, and not just looking at, well, how much can I win in court? But really trying to analyze with your client, well, what does this mean for the business? What does this mean for the individual person to be in this litigation process? And is there a way to approach this more broadly than just thinking about, well, what are the dollars that need to be exchanged? Or what's going to happen in court? So having a thorough conversation with your client before you get to the mediation itself about all of these aspects.
By the way, if I may, just to give a practical example that often comes up in commercial matters, one of the central questions you really want to explore with your client is, do you want to restore the relationship? And either side of the contract, the seller or the buyer, whatever it may be, because there's a whole different approach that one wants to take with a client if, in addition to recovering damages or to recovering money you think you're entitled to, the question is, you also want to have a relationship going forward after this is all over. And the beauty of the mediation process is that it allows for that kind of goal setting, which you don't have in a litigated proceeding. In a litigated proceeding, you either find there's a breach or there's damages, and oftentimes there is no opportunity to restore the relationship. So if the client wants to have a renewal of that relationship, or needs the product or the service of the other side, or needs the job for future employment, not just damages for loss of earnings in a claim of wrongful discharge or sexual harassment or the like, all of these become really critical in how you represent your client effectively, to go beyond the question of who is right and wrong and say, how do we fix this and resolve this matter in this unique forum of a mediation? This becomes absolutely critical for your success in representing your client in mediation.
Right. It really is something of a shift in your mindset about what's going to be needed in order to solve the problem. And it's about understanding who your real audience is in a mediation as well. Because really, because it's not the mediator who is going to determine what the solution is. The mediator is going to help to try to find a solution with you. But ultimately, in the mediation process, the strength of this is that the parties themselves are able to craft their own resolution to the problem. Well, that also therefore means that some time and attention needs to be paid in advance to thinking about, well, how's the other side going to look at this situation? Thinking with your client, and your client may know more than you could about these topics. Well, what do we think the other side is going to need out of this negotiation? And we'll talk about this a bit later in more depth. And how do I present my views in a way that the other side can actually hear them? Because the audience is really whoever the decision maker is on the other side of the table when you're negotiating. And mediation is just that situation with the help of a mediator. But really, the people you're trying to convince are the other side. So this mindset is one about understanding that there is going to be a give and take with the other side on the other side of the table, and coming in with the view to openness, creativity, flexibility in a problem-solving approach. Trying to adopt that mentality yourself and working through with your client in advance that this is what to expect at the mediation. Because in my experience, lots of clients, as they come into the mediation process, they don't really understand that that's what's going to happen. And they have an expectation that their lawyer is simply going to be a warrior on their behalf. But the best mediations are ones where the lawyer has worked with the client beforehand, so that the client really does understand that the lawyer or legal advisor's job is not just to destroy the other side, but really to problem solve together and to see if they can find solutions that allow the case not to have to go forward in litigation.
And in certain cases, this may be obvious, but it can create a good deal of tension between the client and the attorney that's representing them. Let me tell you, in doing work in Eastern Europe, in some other countries, I know oftentimes when it turned out that their lawyers suggested they go to mediation and to try and find a resolution, the response of the clients, I'm going to exaggerate a bit to make the point, is, what are you doing? Don't you believe in the merits of our case? I want you to go in and beat up the other side. They want that emotional and intellectual satisfaction of showing that they are right and the other side is wrong. So I want you to go in there, like as we say, as a bulldog, and bring about success, and have somebody, hopefully the mediator is going to do that, tell them that they're wrong and we're right. And of course, as Howard points out, bring about a mindset in advance where the client understands the process allows them to argue the merits of their case. And while they may be right on the law and the facts, the process really is one where they want to go with the idea in mind, if you will. The way I put it is go beyond the issue of who is right and wrong and meet in some place where you can collaborate with the other side in a way to get a resolution that you can craft, not a court-imposed judgment, but you can craft a resolution that satisfies your real interest in the case and allows you to move forward. And I want to give just one example on that, if I may. Some years ago, I was involved in a property case, and it involved the grandchildren of the person who had died and left to their children and grandchildren a property. It was a beautiful estate. It was a living estate. There was a great deal of land around the estate. And the children immediately started fighting because they collectively were designated to be the recipients of this bequest, about whether or not the estate should be one faction of the family wanted to turn it into a business for money. And they were emphatic they had the right to do that. And the other side of the family that wanted to use it for a residential purpose, it was the other side of the family, it was a large family, many children. They wanted to use the estate, if you will, as a residence. And they had been fighting for almost 20 years over what was going to happen with that estate in the court system, about who had the legal right to do whatever they wanted to do. And it was still going on in appeals with grandchildren involved. Well, they brought this case to a mediator. And this is the beauty of the process that I want to try and illustrate to you, that I hope all of you, in advocating for your clients, and those of you that may become or are mediators, can fully appreciate. What the mediator did in a matter of days is they sat down with the disputing families. And by the way, the families were absolutely toxic with one another. The family relationships had been torn apart terribly over this. They sat down and they said, look, the mediator sat down and said, what I would suggest is you consider the possibility of dividing the estate in some way that you can accomplish both. And they work with the parties, and this is where the parties are really important, to think beyond the issues of right and wrong legally and say, how do we solve the problem? And what they basically did is they set aside the majority of the house to be a residential facility for the families that wanted a residence to live. And then a portion of the house and a portion of the large land was designated to be run as a business. And they agreed that, in fact, those that wanted the residence, if they wished, could basically invest in the business together with the family members that were going to run the business. And if the business was to be successful, which it turns out it was, they would be able to share in the profits of that business. So it brought them together in a collaborative resolution in which the residential family had a place to live. The business people had a place to run their business. They came up with an allocation that allowed them to use the property for these purposes, and further, an ability to share in the success of the business if it took place. Now, no court in the world could ever design this kind of resolution. And of course, the collateral benefit is, by its own nature, it brought feuding members of the family back together, and they were able to rehabilitate most of the family in the process. So once again, this is the beauty and the uniqueness of the mediation process, where the parties, as Howard points out, go beyond the issue of right or wrong and use their mindset to come together and come up with a solution to the real problems, not just the legal issues that are in the case. Howard?
All right. So first, most important element of a successful and optimal mediation process: preparation. Number two, mindset. Number three, for me, is having the right people involved. Making sure that the people who are coming to the mediation, who are involved in the mediation, are actually the people who are going to be able to have the authority to solve the problem. And that means truly identifying who the decision makers are going to be. You know, when your client is just an individual, that's pretty easy. But many cases don't just involve individual decision makers, and real thought needs to be given to who actually is going to be able to solve the problem. In the business, is it going to be if it's a business, is it the in-house legal counsel who is the one who's truly needed? Or is it actually a business person who is going to need to be present, or both, in order to in order actually to resolve things? In an employment matter, where one member of a couple has the employment problem, does the husband or wife actually need to be present? Because if they're not, they're going to sabotage any agreement from behind the scenes. Or is this a situation in which that would be completely unhelpful? So really thinking through, well, who actually needs to be at the table? How do we ensure that we're going to have people with real authority to solve whatever the problem may be? As a practical matter, particularly in cases that involve public entities, in our experience, it may not be so simple to get the final decision maker present. Sometimes it's a whole board, or something has to be approved. The mediation process can still be successful if those issues of authority are on the table before the mediation. so that for example, if the plaintiff, I just had a case this last week where the individual plaintiff, employment, an employee problem, and a public entity employer. If the employee and the employee's advisors had not understood what the decision-making process was going to be inside the public entity, the negotiations probably would have fallen apart because the plaintiff would have been so upset that the right people weren't at the table. But we were able in advance to make clear, well, here are the people who are going to come on behalf of the public entity. Everybody knew in advance that they could only make contingent agreements about what might work and that they were going to have to be taken up some other chain of authority. Having all of that identified in advance and clear to everybody meant that we did actually have the best people we could get at the table, and no upset on the part of the plaintiff when in fact it couldn't be resolved that day, but we needed a process by which the defense could get the approvals that were needed in order to finalize an agreement. So really, again, thinking through, well, who has to be there for this particular dispute, and how do we assuring that you've got those people present and that it's transparent, and there aren't any surprises about the question of authority. Any thoughts on that issue?
No, I think you've covered it really well. Sometimes what you may want to do, if you don't have somebody that's actually present at the mediation with final authority, is get the parties. We'll talk about how you do this in a pre-mediation discussion, at least to have telephone access, because as you can appreciate, in almost all mediations, you get to an impasse pretty quickly, and usually the authority that you initially have, it turns out that it is not a sufficient amount of authority, and you need to go to close the deal at the end of the day to get some additional authority. So they may not in fact be present, but they may in fact be accessible to you, so you can close the deal in a way that you couldn't get the authority before you actually went into the mediation session itself.
Absolutely. So there's an interesting question that has been presented. The question is, in my experience, clients' attitudes often change. After many months of trial or the litigation process, they are more willing to mediate than at the beginning of the dispute when emotions are high. Very astute observation.
What we call the bloodletting process. What's that about?
And really, it's so interesting because the very next point on my list about elements of a successful mediation process has to do with timing. So the questioner is right on track with where I had hoped to go in this conversation, because it is absolutely correct that sometimes clients aren't ready. Sometimes there's not enough information on the table. Sometimes there needs to be you need to be deeper into the litigation process. Sometimes you don't have enough information at the outset. And in our system, that looks like what we would call pretrial discovery. And in your system, perhaps it means that you have some earlier elements, the beginnings of the trial, to get information on the table in order to have a successful mediation process.
And sometimes it's after the trial's begun that you actually get information that has you rethinking.
That's right. So the way that we think about this is that there really are many different settlement windows that occur through the life of a dispute, and we encourage counsel to really think about all the different settlement windows. And when we work with judges about referring cases, the same concept is important. But the first important settlement window and mediation possibility, I think, occurs before the case is even filed. So increasingly in my mediation practice, I have parties agreeing to come to mediation before the legal action has actually been filed in court. and because once that court process begins, the court process itself can have a really negative impact on relationships. It's, in our system, it's costly and time consuming. So the first opportunity is as soon as the problem appears, and increasingly we have the legal counsels agreeing in advance. Well, before we even commence the mediation the litigation process, let's try with a mediator to see if we can resolve things. Particularly useful when the facts are pretty well known, and when the parties have a pre-existing relationship that they truly want, where there's any interest or any possibility in preserving that relationship, because the litigation process itself is going to be damaging to the relationship. The next window.
Excuse me, I want to add something before you
Sure.
get to the next window.
Great.
Building on that point.
Yes.
Oftentimes, it's not just the party's willingness. In fact, and this may be foreign in Poland, I don't know. Counsel oftentimes will take that initiative, and before they file a formal complaint, will call the other attorney, particularly in a community where they know one another, but even sometimes where they don't, will contact the other side and say, look, I'm about to file this complaint on X, whatever the subject matter is. I'm happy to send the draft to you, which I'm about to file. Are you interested in mediating the case? And I will tell you, in the early days, every lawyer initially declined, not every lawyer, almost every lawyer declined that for fear that by accepting it, it might imply that their client's case was weak in the defense. And they didn't want to appear that way to the other side. And that has become truly historically irrelevant now in the most sophisticated business environments in Silicon Valley and generally across the country in America, in the United States. It is not at all unusual for a lawyer to call the other side, particularly when the lawyers know each other, but even when there's a strange relationship, but the firms are reputable and respected firms, for one to call the other side and said, look, we are going to file this complaint. Do you want to consider it? And the other side to say, well, let me explore this with my client. I'll talk to you a little bit later. We'll talk to you a little bit later about dealing with the client and how to explain it, but dealing basically with one another directly and finding that it's suitable to go forward. And we would encourage you, where you have a relationship with an adversary, to consider that as a possible opening and window to initiate the discussion. And I assure you, it will not hurt you later on when you have to get down to the mat and litigate these cases. You'll show you how to litigate if you need to do it.
So the next important window, I think, is obvious. It's right after the case has been filed, but before you've done really much work on it, before the court has become actively involved in the case. And then the question is, at key points in the litigation process itself, just before or after key decisions that the court might be making, motions to dismiss. In our system, we have something called motions for summary adjudication, where short of bringing all the witnesses in person, decisions are made more based on settled facts and legal propositions. So just before or after important benchmarks within the course of the litigation process are important timing elements. And even after the court has made a decision, really an important window occurs between the decision of the trial court and the appeal. Because as Claudia could certainly speak to, there's a great deal of success in mediating cases in the window between the trial court's decision and the matter being taken up by the appellate court. So yes, timing and really trying to figure out in this particular case what's the best timing to move things forward. And in our mediation practice, getting a mediator involved early sometimes lays that groundwork as well. So you might try early, determine that it is too early and something else needs to happen in the legal case. But then the mediator is familiar with what's gone on, and you can come back for a second or a third attempt at mediating the case along the way. Any other thoughts about timing? Or maybe Claudia should say a few words about appeal. There's a question. How do you handle situations where the parties in dispute are unequal, such as in employment law cases, but still the employer or any kind of party which has the upper hand in terms of resources doesn't want to settle because they can afford to litigate for much longer and never run out of money, whereas the weaker party doesn't have that luxury?
Well, since it's an employment case, I'm going to kick off the first response. That was my area of specialty for the 50 years in which I engaged exclusively as a litigator or employment matters. And the answer, at least in my mind, is to dig a little bit deeper with either side that feels they have, in any one of these cases, that they have nothing to lose by dragging it out. Because I have yet to run across a mediation in which dragging out alone is the right answer for that party. That there always is some significant advantage, if not a great advantage, in moving that party to a resolution early on. It could be the cost of the attorney's fees, even if they win at the end. It could be the impact on the business where all your key executives are being drawn into the litigation in all kinds of what we have as discovery and depositions, and also distracted in terms of their responsibilities, as well as internal issues. Because you can rest assured, you raise it in the context of an employment case, when employees file these lawsuits, they're almost generally well known within the workforce. And the position of the company and the employee, whether for example, other employees view the company as acting unfairly to somebody, or other managers feel that the company is not adequately, aggressively defending the case, is looking weak in the face of employee claims. All of things affect the morale of what's going on within the corporation. And once again, I am speaking from very real experience in representing mostly corporations over the 50 years of my career. So what we do in situations like that, when we're asked to try and help convince a party to take it to mediation, or we're asked by a party, what are the advantages to go to mediation in a situation like this, is we point out what the benefits are versus just going through the litigation situation, among which, of course, is the possibility that you're going to lose. That it's not only a question that you might win, and that win cost you a fortune in legal fees. That win might have cost you a great deal of loss and distraction of executive and management time. But there is always, as I like to put it, in a gunfight, you never quite know who's going to get shot. So it really is important to take that into consideration. And often what mediators are very effective in doing in the mediation process, and perhaps we'll have a time to talk about this, they actually work out, if you will, a bit of a decision tree. Each of the stages of what's going to go on in litigation, what are the chances of success or failure, and what ultimately, even in early success, the cost may be, and certainly with appeals and the like, what those costs may continue to be. And hopefully that brings out, if you will, the more rational element. And that is such, for those of you that have a business focus to your practice, and my understanding that is the core and essence of your work, this is where you can provide such excellent business counsel to your clients about the value of mediation. And perhaps we'll talk about this later on, because initially they may resist it. They may feel they want to litigate. They want to show the other side is wrong. There's a lot of anger that they've been accused of some inappropriate conduct of some kind. And they want to win, and they want the other side to be told that they're wrong in one way or another. And one of the responsibilities that you have without losing the client is to at least give them the option to consider this possibility of mediation, hopefully persuade them to try it without the loss of their opportunity, if they wish later on, to go into litigation, and you don't have to go to mediation and give up that opportunity if that's what you wish to do so.
What do you have any thoughts you wanted to add? Or okay, in answering this question, I don't want to sound callous exactly, but the unequalness of the parties is often a reality. And my job as the mediator is not to force or push or coerce the parties into settling if it is not in their interest. And the fact is that the weaker party sometimes needs to understand that they are the weaker party, and they need to think about whether they are better served by settling for perhaps less than they would ideally get if they took the case to court, but they need to make their own decision about that. And the stronger party, who may not want to resolve the case because they think we need to work with those parties to identify the reasons why it would be useful to solve the case. And that's to resolve the case. That's much of what I think Vic was talking about. But at the end of the day, if the stronger party simply wants to litigate because they're stronger and they believe that they can win, and that is their considered judgment that they are better served by moving forward, in mediation, unlike court, my job as the neutral is not to not to make a judgment about this. My job is to assist the parties in figuring out for themselves whether they're better served by resolving the case or going forward with litigation. And sometimes litigation is that the participants determine that they do prefer to litigate, and that's all right. It's not mediation isn't a settlement at all costs kind of situation. And the reality is that the weaker and I can't alter the fact that one party is weaker or not. That they come to me with the power, with the powers that they have.
But Howard, wait a minute. If you're the mediator,
yeah,
and you see there's an unfairness, and one party, for example, is not being well represented, and they're about to consider a resolution that is far less than they are really entitled to, and the stronger party with the better attorney that's arguing more effectively, and the bullying is going on from the stronger party, don't you play some role as a mediator to try and bring about some fairness in a situation like that?
My job is to create a fair procedure. It's not about, the parties have to come to their own result. So there's a couple aspects to this question that you're asking, Vic. And one, so bullying, certainly it's my job as the mediator to ensure that the kind of conversation that we're having in the mediation process, that nobody's being bullied by the other, that we are having a respectful conversation about what's likely to happen if the case doesn't resolve, and such. But it isn't my job to put my thumb on the scale and help the weaker party.
What if one of the I'm sorry, go ahead, Claudia.
Well, but what I want to say that I think that it is your job as the legal advisor to actually be the factor that helps create a more balanced situation. Because a weaker party with an excellent lawyer is a much less weak party. And we see that all the time. And we often see that the stronger party will come to its knees in the face of a really good advocate who can present a really good picture about why their client was damaged and why their client deserves some kind of compensation. So in my experience, it's really your job to be the ones to help balance that. I know, Vic, in your question, you were saying part of the weakness was that the lawyer was weak. If you have a weak client and a weak lawyer on the same side, that's a big problem.
That's right. That's absolutely right. And, and you as the legal advisors, it is your job. Ultimately, the legal advisors, the lawyers, it's their job to represent their clients' interests. It's our job as the mediators to give everybody fair opportunity to set forth their views.
Good.
Right?
Oh, I do have one other sobering thing to say
Yes.
about this last subject, and that is, in my experience, there are certain large companies, usually retail companies, that are large companies that get sued all the time. They get sued because they have thousands and thousands of employees nationwide, and they have hundreds of thousands of customers. And some of these corporations take the position that they will never settle any case, no matter how good the case is, because they have analyzed, whether correctly or not, that their long-range interest is served by not settling. Because if they get the reputation that they will settle a case, they're worried that they're going to open the floodgates to lots and lots of litigation. And I think it's important to know who those companies are. And in fact, they've been successful in curtailing litigation because of that policy.
And in many of those cases, by the way, part of the terms of a settlement can be confidentiality, which is enforceable in our system to such a degree that if somebody breaches the confidentiality of that settlement, indeed, you can provide provisions for very substantial punitive payments if they breach, to really make sure that it's being enforced.
Absolutely. And I think this circles back to, is this a case that's appropriate for mediation?
Mhm.
Right.
If you've got one of those companies that is going to take this approach that Claudia describes. There's another question here.
Yeah, as a mediator, getting back to the situation when you see that the settlement is unfavorable to the weaker party, which is acting without an advisor or counsel, I assume, and the weaker party is willing to agree to the settlement, do you ever tell the weaker party that it should use an advisor? Can a mediator do that? Now, those are two questions.
All right. So,
Okay.
so I want to start by saying, as a mediator with a party who is not represented, the very first thing that, before we even begin the negotiations, it would be to suggest to the party who does not have any kind of advisor or counsel that they would be well served. So it's very much my job as the mediator to suggest to an unrepresented party that they would be better served by having an advisor to assist them, because otherwise they will be at a disadvantage.
Well,
So
won't you give them advice if they don't have a party?
Never.
Okay, that's the key.
Never.
Why not?
Because my job is to be a neutral and impartial person. I can't. It's a conflict for me to give legal advice to either side, and that's particularly acute when one of the sides doesn't have appropriate advice and counsel from an appropriate attorney or legal advisor.
There's an aspect. I'm sorry. Go ahead, Claudia.
Well, I want to say, in my experience, this is the worst possible scenario for a mediator, is to have a represented party and an unrepresented party. And
Yes.
I have to say, in my practice, I wouldn't do it. I mean, I just would not mediate with unrepresented parties, because I think, partly knowing myself, I couldn't stand it. The scenario that is in the question, I would feel too terrible. But I wouldn't want to breach my duties as a mediator to be impartial and to be neutral. And this situation calls out for you to do that. And so for me, it's just too much. I'm too kind-hearted. I think it would just hurt me to see somebody be throwing away their rights in that way.
Right.
And so I just would not take these cases.
Well, and so in our courts program, in order to deal with this situation, because we had too many unrepresented parties to simply say, no, we won't service you. So in our courts mediation program, we established a program in which we could ask the court to help find a lawyer to represent the unrepresented party for the limited purpose of the mediation.
On a pro bono basis.
On a volunteer basis, that's right. So that the unrepresented party would not have to come into the mediation process like this. And we have had some real success with obtaining volunteers to help the unrepresented party, because it is such a conflict for the mediator, as Claudia describes it.
Right, and we did in my court. We did the same thing.
So one aspect of this that I want to raise, it's related sufficiently, I think, to raise it. What if the mediator is asked, "What do you think I should do?" This commonly can occur if you, as a mediator, are successful in building trust in the parties that are subject to this dispute. It's not uncommon in a private caucus that takes place where you're speaking with the party and their counsel, and the party is interested that they seem to trust you enough to want to know your opinion of whether they should accept a particular proposal. And I want to just put out there, at least in my practice, is under those circumstances, I never, ever express an opinion as to what they should do. And the reason I have this as such an ironclad and hard rule is that once you express an opinion in that way, I feel, despite your good intention, you have now reflected a bias in terms of how the case should be resolved. And the most important thing that you have, the most important quality that you have as a mediator, is the integrity of your being an unbiased facilitator of the resolution. And the second aspect is that the decision made by any party to resolve a case is truly their voluntary resolution. So if I'm asked that question, as happens from time to time, I explain to the party with counsel present that I appreciate that you would respect my views and seek it. But what's most important here is the essence of this process, that it be something that you feel comfortable with, that you voluntarily believe, that you want to choose as a resolution. And if you so choose, you're willing to go on and move forward with your life. That's what's important. And anybody can second guess you, or anybody can express an opinion of what you should or shouldn't do. But that's not what's important. What's important here is that what your wishes are, your needs are addressed by whatever this proposal is, whether it's money or relationship or some other non-monetary aspect, whether it's reinstatement to the job or payment of back wages. All of that is for you to decide. And that maintains, of course, your ability to be the neutral and helps them make the decision that they really want for themselves.
I want to say, I answer that question differently. If somebody says to me, should I do this? Is this a good deal? I will often say, I've mediated other similar cases, and other people have settled their cases very similarly or in the same range. So I'm not telling them what to do, but I'm giving them some sort of information that helps normalize this particular settlement. I mean, I'll only do that, of course, if it's true. But people find it very comforting to know that the way that they're settling the case is in line with the way other people have settled similar cases.
Okay. Yes. My practice is similar to Claudia's, but fundamentally, I think we're all saying the same thing. You can't tell people what to do as the mediator. They have to make their own decision for themselves. Another element that I think is key to having a successful mediation has to do with the use of written mediation statements in advance of the mediation that are prepared by the advisors, by the counselors to the clients in the mediation. As a mediator, it's important for me to understand what the case is about at the outset. Among the things that the participants in the mediation process are doing is to compare what they might get in court with what might be available in the negotiation process that occurs in a mediation. And at various points in the mediation process, I might be called upon to help the parties think through how the litigation alternative compares to any settlement that is on the table. So I want to have at least a basic understanding of what is the legal case all about, and that's really aided by as the mediator, having in advance essentially position statements from the participants about the legal problem. I may want to read some case authority or look directly at the statutes, and having that cited to me in advance is quite helpful. But more important than it being for me, it's about assuring that the opposing sides in the mediation have shared with each other their views. And the earlier in the litigation process, or if it's pre-filing, pre-lawsuit filing, it's important to know that the opposing lawyers have shared their views with each other. So we have a practice where, in advance of the mediation session itself, the legal advisors prepare and exchange their mediation statements. Sometimes they're referred to as mediation briefs. I have to say I prefer calling them mediation statements because it's not only a legal brief. It can be broader than that in terms of what is most important to each of the sides. In my ideal practice, the parties exchange these writings at least a week before they come to meet with me. They also have the opportunity to prepare something confidential that they send just to the mediator for the mediator's eyes only, so that there is both an exchange of information, but also an opportunity for each side to tell me if they are things that they think are important to them that they're not quite prepared to share with the other side, at least not in advance of the mediation. So this is a real opportunity for the legal advisors, for all of you, to really set the table properly to have a successful mediation process, to present your best picture of why you have a strong case, not just to the mediator, but to the opponent. And in writing these statements, the best ones really consider the audience for the statement. So the audience is in part to advise the mediator of what's going on, but really they're an opportunity, an important opportunity for you as the legal representative of your client to show the other party just why it is that you have a strong case. So preparing really good mediation statements, thinking about how much you can share with the other side. It's opportunity kind of to tell your story before the mediation in a way that will help advantage you in the negotiation as it begins in the mediation itself. Is really, it sets you up for a successful mediation process to have had well-crafted exchange of mediation statements, and to key the mediator in on anything you think the mediator needs to know beforehand. So the most common thing that people talk with me about in confidence, and there are a couple mechanisms for this, but often it comes in the confidential mediation statement. The counsel might write me a private letter saying, we have some internal difficulties with this case. My client, or it might be some insight into who the client is and what might be helpful to the lawyer may need some help with their client to help the client understand that the case isn't quite as strong as the client thinks it is, or that they're going to have some difficulties. And keying the mediator in advance through the use of a confidential writing about what's going on can really be helpful. Or you might think that you've got an important piece of information that you don't want to share with the other side yet, but you want the mediator to know. And the mediator can help you figure out how best to utilize that in the negotiation process. So thinking about those materials and what you might want to say to the mediator privately before you actually begin the mediation. That can come in the form of a mediation statement. It can also be more informal than that, and we'll talk in a minute about, in addition to these written statements, the idea of having some kind of phone contact with the mediator in advance. I'm going to pause about mediation statements first.
Well, yeah, I want to just raise one point that I think a number of you on this Zoom conference may be thinking about. We get paid for all this work, okay? This is not a situation in which you've got to do this and you only get paid for the time in the mediation or a narrow period of time in preparation. All of this work is paid for. And as someone that built in my firm, it was a tiny firm of only, let's see, we had 125 litigators, we had 300 plus 350 lawyers. These people made a lot of money in their hourly fees in litigation. And of course, I suspect that a number of you thinking about, well, wait a minute, who's paying for all this? Now, I raise this because to the extent you wish to raise questions about this, practically, perhaps it's difficult for you to get paid for this. There are approaches that need to be made with clients so they're open to paying you for these valuable services. And we view in the United States, certainly the services we provide that Howard's talking about in preparing for the litigation, and certainly, preparing for the mediation, and certainly in the time in the mediation, we view this just as valuable as our skills that we're all trained on as advocates in the court proceeding itself. And we charge fully for these services. Now, some firms come up with creative arrangements where they may work up a modification, do something less to encourage the parties to fully engage in the preparation at lesser cost, and then they get their return once they're in the mediation itself, and they charge more fully. You can vary this, but the element I want to inject in here is that all this preparation time, in addition to the time you spend in the mediation itself and afterwards in writing up the agreement and enforcing the agreement, all of this, I think, in a healthy system, is one in which the attorneys are fully and appropriately compensated.
Great. Yes. So in addition to the idea of having some written statements prepared in advance, the other practice that I want to talk about, which we use almost universally in our mediations, is the idea of a pre-session phone conference with the mediator. In our practice, actually in my court program, the mediators who served as the mediators through the court, it was mandatory that the mediators set a phone conference with the lawyers, with the representatives, pretty much as soon as the case was agreed to come, as soon as possible after the case was agreed to come to mediation, excuse me, so that the mediator could talk with the opposing counsel and plan out and really customize the mediation to the needs of the particular participants and the particular case.
You mean talk with both counsel?
Talk with both counsel, and the call would be set with both counsel and the mediator. No clients. This is just for the lawyers and the mediator, so that they can plan out together what is this particular mediation going to look like. Because in our experience, there really is quite a range, and we'll talk later in the day about the range of styles that mediators use, different practices, and it's really crucial if you're going to do appropriate planning for a mediation process. You need to know, well, what is this mediation going to look like? Is this a mediation where the presumption is that the parties and the lawyers and the mediator are all going to be together in one room, mostly for the whole of the process? Or is this a mediation that is going to be much more focused on shuttle diplomacy, where the parties are in separate rooms and the mediator is carrying messages back and forth? Or is it some combination of those things? And and sometimes one is appropriate, sometimes the other is appropriate, but you can't possibly prepare properly yourselves or with your clients if you don't know in advance what's this mediation actually going to look like. It's an opportunity for the mediator to meet with the lawyers and talk through, well, what are the mediator's expectations? What are the lawyer's expectations? What are the special needs, if any, of the people who are going to be participating?
Is this done by phone or in person?
So we do this by telephone. And now we do it a little bit by Zoom, depending on the situation. But the notion is that, it usually is not a very lengthy conversation. Half an hour is probably the average amount of time that we would spend on such a conversation. But it's a half an hour very well spent in terms of allowing everybody to reach some preliminary agreements and begin the process of building trust in the procedure, and for everybody to know that this is how best to prepare. It's an opportunity to address some of the things that I've already talked about. Things like, well, who's going to come? Who needs to be there for it to be productive? And to share that across the table, because sometimes the plaintiff, for example, will say, well, defendant, don't you need so-and-so within the company? My client tells me that the plaintiff's lawyer will say, my client tells me that if the supervisor of this department isn't there, we may not be able to have a productive conversation. So we can vet that in the pre-session call and figure it out together about who needs to be there, what's the best timing, and even in this day of Zoom, is there anybody who maybe doesn't actually need to be there in person, but we could have them on Zoom, and we could do this in a hybrid fashion, so that we have a higher up decision maker than we might be able to get in person, but we're able to proceed in that fashion.
One of the advantages of this also is that in all my mediations, I do this pre-mediation call. I find it very valuable, particularly where I don't know intimately the attorneys that are representing the parties, is that you get a sense of the mindset of the attorney. Apart from the mindset of the client mindset, usually I want to go in there, kill the other side, get all the damages I'm entitled to, or establish that there was nothing wrong in the first place, or whatever it may be. But I find I can figure out from that conversation whether I have sufficiently informed or sophisticated counsel that they understand what the process is. And in addition, if they don't understand the process, it gives me a chance to educate them. And it's not unusual, although it is the exception. I will sometimes, after the pre-mediation call the attorney so as not to embarrass them in the presence of the other side, and as respectfully as I can, educate them more about what the process is that is involved, that this is not a typical advocacy in the middle of a court proceeding, but rather, and just to prove who's right or wrong here, but rather to move to the point of reaching a collaborative solution. And this is a really very important clearing point. And I also encourage, and I think Howard alluded to this, if the parties decide that they want to have some further conversation before the mediation, confidentially, it's not uncommon for me to get a request from a plaintiff's counsel or a defense counsel and say, look, I got a particular issue I want to talk with you that I want you to understand, but I don't want the other side to know about it, but it will help you be a better mediator. And what I have found is where I'm respected by the parties, they will call and say, look, I got a really difficult client here, Vic. I need you to come in hard on this issue with them. I've been telling them X, they don't accept X, and we know you've had experience litigating X. They need to hear it from a third person. So I want you discreetly to raise this in the course of the mediation. And that will reinforce that they need to get sober about what the realities are and come up with realistic solutions. So all of this can come out of truly most of my mediation, pre-mediation conferences run maybe 20 to 30 minutes, no, not much more, with some exceptions. But they just really are worthwhile spent, and of course have the collateral benefit of building trust, because now the attorneys trust you, what you're going to do to preserve their position of integrity with their client, give them an opportunity to advocate in the mediation the way they need to, but not be running into all kinds of conflict and tension with the mediator, because there'll be enough of that going on that needs to be managed in the mediation itself in joint caucus.
So we understand that having these pre-session calls is not really the practice here. One of the reasons that we want to mention it to you is because we think it's so incredibly helpful. And when we've met with mediators here, we have suggested it to them. But we also think that you might want to ask the mediators to hold the pre-session calls, and that will help establish this as part of the practice here. When we train mediators in the US, we train them to do these calls, and they've become pretty routine practice in many areas in the US as a result. And so we're hoping to seed this as a practice here for you all.
And to the extent in the US that that there are still places where mediators don't do these calls, when we're working with the lawyers in the US, we will tell them straightforwardly that if your mediator doesn't suggest such a call, doesn't just schedule such a call, that it's certainly in our system very appropriate for the lawyer to ask for the call. So again, you'll have to figure out how this fits best into your own practice here in Poland. But we just can't say enough about all the problems that can be avoided by having this pre-session conversation between the mediator and the legal representatives in advance of the session itself.
So this is a good time to just pause for a moment and ask, are there any questions with respect to this area that you want to raise about the pre-mediation conference call, or any aspects of this before we move on? I think we're probably getting closer to a break time somewhere in here, but let's, but we still have actually, right, we still have a bit of time left. So any questions at all that you want to raise about the pre-mediation process, conference calls, briefing and the like that you would like us to explore? Anything come up at all, or nothing at all? All right. Hopefully you're out there and that you're finding that some of this to be relevant. I mean, the main thing we want to get by way of feedback from all of you is that what we're talking about, one, at least has some realistic possibility of being of value to you in the process. And if not, what varies in the way you practice that would prevent this or some similar process from coming about. So please chime in here, especially if you feel that for some reason this is just not workable and we've got to come up and kind of brainstorm together. Had we been in person, we have various role plays and exercises we would do with you to make sure that we've incorporated the true legal cultural aspects here. So please feel free to chime in if you have any questions along these lines. Okay.
Well, I have to say that the next element, kind of the last element that I had identified that I wanted to raise, is really just a segue into really our next topic. So I will put it out there that the other key element to ensure that you are having the most successful possible mediation process is really whether you've got the right mediator, which is the next thing that we wanted to actually begin to talk about. So
I think we should.
So should we take a break?
So do we want to take a break?
All right.
first,
Any
or
suggestions from our organizers? Should we continue to move
continue,
forward?
or we should take a break?
Or continue or take a break? What do you suggest? We can, I would say, another 15, 20 minutes, 30 minutes max. Proceed? Okay, let's go forward.
It might be more. It might be more than that, Vic.
Well, if we
So
can,
let's
we'll break it up if we need to.
Okay, so qualities of a mediator and best mediator selection techniques. So I'm going to try an experiment. Maybe this is going to work and maybe this isn't going to work. But I want to try this and ask you if you would put in the chat what qualities you think are desirable in a mediator. So if you each could write one or two things in the chat that you think are good qualities that a mediator should have.
And we're going to give you a couple minutes to do that.
Right, because
Right.
all that, yeah.
Right.
Good active listener. Okay. Empathetic.
Great.
We're on a roll so far.
Here we go.
Creative guide.
That's good. Flexibility and creativity. Positive can-do attitude. These are excellent suggestions. Experience.
Experience. Good listener. Flexibility. Right. We're getting a couple of.
Thank you for the conference.
The president. Okay, well, we're going to hold off on that. Hold that question. We're because we're in the middle of making this list, so we'll get to that question. Later. Okay, well, thank you very much for this. For those of you who answered the questions about what you think makes for a good mediator, what I really want to say.
I just want to check. Are we still on? Because I can't read what's on here. We're still projecting okay on the screen. Great.
Yeah.
Go ahead, Claudia.
Yeah. So,
sorry.
Your list very much mirrors my list. So empathetic, good listening skills, several said. Flexibility, several people said. Someone who's a creative guide, which was not on my list. I really appreciate that one. Another person had a vote for creativity and a positive can-do attitude. So I really would like to underscore the importance of all of those factors that you have listed. And when I'm thinking about what are the qualities of a good mediator, and also experienced, when I'm thinking about this, I've kind of broken my list into two parts. One are the personal qualities that I would like to see in a mediator, and the other are the professional qualities that I would like to see in the mediator. And there's definitely some overlap between the two. So let me add what I had on my list to the personal qualities. Patience. I might think, along with the can-do attitude, kind of optimism, I would say patience is probably the other single most important personal quality that a mediator can have. The American Bar Association in the US did a survey of hundreds of lawyers looking at what they thought was important in a mediator. And the two qualities that they came up with as the most important were patience and optimism, or patience and the person who said can-do attitude. The idea that, yes, I personally am confident and optimistic that I'm going to be able to help you. Empathetic, that someone mentioned that. And what do we mean by empathetic? Somebody who is able to listen hard and carefully to the lawyers and to the parties and to demonstrate that they have listened. Somebody who is also kind and caring. Also on my list is open-minded. That is somebody who's not prejudging the case, somebody's not prejudging who the people are, but really open to whatever it is that the parties bring to them, and is also open about the process, that is not rushing to conclusion. And I will say that, so in my role as Chief Circuit Mediator at the Ninth Circuit, I hired many mediators. We had a program that was unusual in the US, in that we had 9 staff mediators. So these were professional mediators hired by the court. Because I was in charge of the program, I would do the hiring. And what I started to learn over the years is that these personal qualities, basically the temperament of a person, was the most important, assuming basic qualifications. The temperament was the most important piece. And part of that temperament was this idea of openness. Part of the idea that someone was not going to be a person who rushed to judgment, who rushed to force the parties to closure, but allowed them the process to be open and to follow the parties where they needed to go. And so one of the jokes was with this, that the people who got their applications in first, like the day that the application period opened, were not the people we wanted to hire. And we would look to hire the people who got their applications in at the last possible moment, because those people tended to be the ones who had the most sense of openness. Now, this was a joke, but in actuality, it did turn out to be that the ones we liked the best were the ones who kind of waited till the end to get their applications in. Okay, we mentioned good listening skills. Somebody who's got basic intelligence. Somebody who's caring, someone who's curious, really wanting to understand who are you and what matters to you and how can I help? Someone with good communication skills, and someone who is good at regulating their own emotions. As a mediator, we are in the middle of conflict all the time. So we spend our days sitting between people who are mad at each other. This is actually not an easy thing to do. And so what a mediator has to be able to do is not get caught up in the emotions of the people that they're working with. Has to be able to be like water off a duck's back, or have an ability to, if they do get upset, calm themselves very quickly and very easily, because there's nothing worse than the mediator reacting emotionally to the emotions of the people who are before them. So that was kind of my list of the personal qualities. And on the professional qualities, interestingly, what you all gave me back was experienced was kind of the only one on the professional qualities side of this. We did this exercise when we met with the judges on Monday, the judges at the regional court. They were not interested in the personal qualities. They were really interested in the professional qualities. And they talked about training and experience and subject matter expertise. So I think it's interesting the different perspectives and how you all who have commented are really, and I think correctly, interested in the personal qualities. I don't sell the professional qualities, because of course you want somebody who is experienced, somebody who knows what they're doing, somebody who has actual mediation skills. And we understand that there's probably some variety here in the skill level of the various people who put themselves out as mediators. That is certainly true where we come from as well, and with the people we've worked with in other countries. So of course you want somebody who is very well trained and is highly experienced. The question of subject matter expertise: do you need somebody who is an expert in the particular kind of law that your case arises in? This is a matter of some controversy. I personally, and I think most of us, feel like subject matter expertise, with, let's say, the exception of maybe family law, is not necessary. What is necessary is that that you are a lawyer to begin with, that you understand legal principles, and you're a quick study, so that when you get the pre-mediation statements, when you talk to the lawyers, when you've read up about the case, you have a quick ability to kind of grasp what the legal issues are and what's important. But as Howard has kind of taught me, is that oftentimes when you have too much expertise, you get as a mediator, you get a little narrow about how you look at the case. You're really only looking at the particular legal issues rather than looking at the case more broadly. So what we like to think is that you want a mediator who has excellent process skills, who's very well trained in mediation, who's underlying a good lawyer, but not necessarily need to have somebody who knows tort law intimately, or contract law, or whatever the case is.
If I could just
say
please. A word about that. As a practical matter, I guess it's sort of what the level of legal knowledge is that's actually required. In my experience, I guess the one gloss I would put on that is that I do think that a mediator, whether the mediator is a lawyer or not, needs to know enough about the topic, the legal problem, to be able to ask intelligent questions and to understand the legal context, so that you, as the legal advisors, don't have to provide, sort of a fundamental tutorial. For example, if you have an employment case, or you have an intellectual property case, copyright infringement, for example. You don't want to have someone who has zero knowledge, who doesn't understand the basic principles of copyright law, in my opinion. But you also don't need the world's greatest expert on copyright law. You just need somebody who can understand the fundamentals.
On the other hand, one can argue, for example, in family law cases, do you have to be knowledgeable about family law therapy and so forth? And you can argue these things almost any way, but I think the quality that Claudia talked about, which is an open-mindedness and a willingness as a a mediator, I know I've had to learn so much in some of the cases in advance of my mediating the case. Or in fact, when I got the briefs, I realized I needed to develop a better understanding of the law or the facts. I was telling I was telling Claudia and Howard, I recently was assigned a case. In fact, it was one of the federal court cases. It was a boxer, a very well-known boxer. And there was a major dispute going on between the promoter, the ring, and boxers had, I don't know how it is in Poland, but in the United States, they got 1 million handlers, all of which have a piece of the boxer. I was like blindsided by all the aspects of the complexity of what was a very simple claim for payment of the boxer. So I went out and I did a lot of research about it. And I think that goes to Claudia's point that it's got to be somebody, if they don't have the expertise, that is sufficiently motivated to learn, as Howard has said as well, enough of what the dispute is about to deal with the subject matter intelligently. There's also one other quality that we haven't explicitly pulled out that we've all, by inference, talked about. That quality is persistence. It is really important that, and also a sense of optimism that goes together with that persistence.
Yes. Good point.
Okay. And that is that you've got to never, my mother is turning over in her grave right now. She told me to never say never. Never give up on the case. I've had cases, one case in particular, which illustrates this beautifully. The mediation failed. They went to trial. The jury was out deliberating who was going to win, who was going to lose. Both sides were getting really nervous after they saw what happened in the case. And I contacted the parties. I said, well, maybe now you're all here sweating, waiting for the result. Maybe now you might want to mediate the case. And then we mediated the case, got it resolved. And the only people that were really ticked off were all the jurors who came in ready to give a verdict, and they weren't needed. But the point being that you just never give up, and you got to look for what those opportunities are there in order to make sure that you've exhausted every opportunity. And after this bloodletting that Howard referred to a little bit early on, sometimes they've got to beat each other up quite a bit and then spend some money and see the complexity of the case in a different way before they're open to a positive mediation experience.
Yeah, well, thank you for raising the persistence point, because I did omit that from the list. I think that when you are looking for, well, let me say about the subject matter expertise, both. I was talking really about kind of legal subject matter expertise, and then Vic brought up that very important point about subject matter expertise. One of the things that was wonderful for me about my job at the Ninth Circuit was after 30 years, I still would get both legal areas and subject matter areas that I had never heard of. And I felt like after my time there, I had a stadium's worth of information about so many different industries that was about half a centimeter deep, but very broad. So I learned about uranium mining. I learned about horse breeding. I learned about prison conditions. I learned so much about healthcare and about government contracting. So many, many, many things. And it was always interesting because of my personal quality of being very curious about all sorts of things. So I think that the point you make, Vic, is really so well taken, that you want to have a mediator who's going to invest themselves in really learning about your case and really learning about what's important. We understand that one of the issues with that, which I'm sure is of concern to you, has to do with compensation of mediators, and that some of the mediators in the court programs are a little concerned that they're not well compensated enough to invest themselves in this. So this is a larger, I think, a larger concern, and something that you all and they all and the courts really, might want to invest yourselves in working on, because I think that you want the mediators to be adequately compensated to do the kind of job that they need to do and really invest themselves in learning about boxing or uranium mining.
Yeah, I think that point is, I want to emphasize, as someone who was and is a panelist for many years on these cases, and there's an option under the district court system. The parties are obligated when they go to the court program, they're at least to commit a 4-hour commitment to the mediation process at a minimum. But they obviously have the option of asking for additional time, 8 hours or more. And in fact, there's a compensation system in which the 4 hours are pro bono. And after 4 hours, the panelists from the mediation program, the court mediation program, can require, which I do, can request and require that there be payment at the prevailing rate of that mediator, which gives them some financial motivation to be even more conscientious about it. But I will tell you, for my own part and the others that in collective sessions, training sessions of the mediators in the federal program, I have been really impressed by the genuineness of their commitment to understand their cases, even where it puts in, you've got to put in the extra time. And it is quite rare for me to find, even in a 4-hour mediation, that I'm not putting collectively with everything, with the preparation and the pre-mediation call and the reviewing of the briefs and the analysis of the issues and a little bit of research here and there. It's rare I don't end up putting at least 6 to 8 hours or more in addition to the mediation in order to get the parties to a resolution. And as a result, in my particular case, I've been able to have a very high percentage actually of resolution. And the parties know when you're doing that, and they get more serious when they see that you aren't doing just a shallow and superficial job, but you are taking the case seriously. So that is really important.
Okay, so let's talk a little bit. Anything more you want to add about mediator qualities?
No, that's great.
Okay, so let's talk a little bit about how to choose a mediator. But Christopher, I need your help to get the PowerPoint up. Okay, great. So
You want to move it forward?
yeah, moving forward to
Hey, there you go.
second one, next one. Okay, so how do you choose a mediator? Those of you, many of you have had experience in mediation, and you may have had the experience that one mediation looks nothing like another mediation. And the way one mediator operates looks nothing like another mediator operates. There is an incredible range of difference of what happens inside a mediation process, depending on the case, but largely depending on who the mediator is, how they've been trained, what their background is. So this grid that you're looking at is something that was prepared by a mediator in the United States to help try and make some sense out of the different experiences that litigators had with different mediators. So why does one mediation look so different from another? So you notice that we have two axes. So let's look at the north-south one, the vertical one. This is the role of the mediator. On the top, you see the word directive. On the bottom, you see the word elicitive. So these are different ways that a mediator can organize the case, relate to the parties, relate to the lawyers. So a mediator who is directive is basically one who is going to tell you how the mediation is going to look, and is often going to listen to you and then tell you maybe what they think, give you suggestions about how to resolve the case, maybe even tell you what they think the value of the case would be if it actually went through to a judgment. On the bottom side is the word elicitive. Not actually, the word elicitive is so uncommon that it always shows up as a misspelling on spell check when you write in English. By elicitive, what we mean is a mediator who will pull things out of the parties and out of the lawyers, will elicit from them how they want the mediation to look, how they would like to resolve it, what's important to them, what matters to them. So the mediator will elicit from the parties and from the lawyers what matters, what they think. Then you notice on the east-west axis, or the horizontal axis, it's called problem definition. So how is the problem to be solved defined? The problem, so on the left side you see narrow. So often the narrowest problem to be solved is the legal case. Are we going to just solve the legal case? And we're going to solve the legal case only by looking at the risks and benefits of proceeding with the litigation. That is, who's likely to win, who's likely to lose? Can we attach a value, a monetary value to those risks and settle the case that way? On the other side of the spectrum, the other side of the axis, it says broad. So what else are you going to look at in order to get the case resolved? Are you going to look at the relationship, the personal relationship? Are you going to look at the business relationship? Maybe are there some community interests involved? Might there even be some larger societal issues that can be incorporated into how you look at the resolution of the case? That is this going to help? Is this going to affect other people? So when you're defining the problem, this is among the options that you can look at to get to define the problem. So legal issues narrow, all the way into societal issues more broadly. In the litigated case, most mediators will always help the parties understand what their best alternative to a litigated agreement is, to a negotiated agreement, and what their worst alternative to a negotiated agreement is. In the litigated case, that almost always is, what's a judge going to do with this case? How is this case going to be decided? But there are elicitive ways of evaluating the case, and there are more directive ways of evaluating the case. So the more elicitive ways that a mediator might use to evaluate a legal case would be open-ended questions. Like, gosh, Madam Legal Advisor or Mr. Legal Advisor, tell me, what do you think are your strongest claims here? And where do you think you might have the most difficulty? And then moving more and more in the direction of directive, one of the things a mediator might do would say, well, gosh, let me tell you, the other side has said X, Y, Z. So what do you think? How would you respond to the other side's arguments that whatever? Then a mediator could ask more leading questions. Like, what do you really think about this claim? I've heard that this, in my experience, this claim is not likely to succeed, but what do you think about that? Or the mediator could flat out give their opinion as you're moving on to the more directive side, where the mediator gives their opinion about the law, and even more directive, the mediator gives their opinion not just about the law, but the actual value of the case. So this is sort of an example of one activity, the evaluation, that's likely to happen in a mediation, and the different ways that an elicitive mediator and a directive mediator would handle that.
Just pointing out that many mediators use both qualities in the process.
Yes.
Some may be more or exclusively one or the other, but most of us, I think, tend to use a mixture of these various approaches in conducting the mediation.
Correct. And there is a joke in the US that mediators are elicitive in the morning and directive in the afternoon.
When everybody's tired.
When everybody's tired or when they're trying to get some sort of closure. Okay, I don't think we. I don't think we need the PowerPoint. A PowerPoint anymore.
Right, so let me. You can take away.
Yeah, you can
take away the PowerPoint.
Yeah. So, for you all as advocates, as legal advisors, as legal advisors, it really helps to do some research about the mediators. What's this mediator style going to be? And in addition to the different styles, the mediators often have different practices. And by different practices, I mean how they structure the mediation. What does the actual mediation session look like? So there are some mediators who will keep everybody together in one joint session for the entirety of the mediation. There are other mediators who will keep everybody separate for the entirety of the mediation. They will never meet together. And there are other mediators who will start out with everyone together and then maybe meet with each side separately as the day progresses and maybe bring them back together again. And there are some mediators who will do any of this depending on the particular case and who the parties are, and might make these decisions together with the lawyers in the pre-mediation call. There are other mediators who have a set practice and always follow the same practice. So you can see there's a lot of variety. And again, one of the advantages of the pre-session call is it allows you to understand what that mediator's practice is. Or even before the pre-session call, you can do some homework to interview the mediator or talk to other people who've used them or look at their websites to really determine which kind of practice they do and which of those practices you think will be most beneficial to your particular client and your particular case. Among the other practices that you want to look at is how long do they schedule a mediation for? Is it 1 hour? Is it 8 hours? Is it 2 hours? In family law cases in the US, family law mediators typically schedule many sessions. So they'll say have 2 hours this week, another 2 hours the next week, another 2 hours the following week. In our practices, mostly in commercial cases, we schedule them for a day. But that really varies. And so you will want to find out from the mediator what their practices are. Do they do Zoom mediation? I think since the pandemic, a lot of the mediations now have been on Zoom. Some mediators don't even want to ever mediate in person. Some lawyers don't want to mediate in person, and some mediators want always to still come back and be in person. So those are among the various kinds of issues that you're going to want to think of when choosing a mediator. So I'm thinking maybe we should take a break. It's about time to take the break, yes? And then go for another couple of minutes and then have questions.
I have a couple of comments about this. I don't know if it does
okay,
as well.
super.
So maybe we could do that before we.
Super, and then we'll take a break and then have questions.
So I think the main point that I wanted to add is that in our practice, the representatives of the parties, often it's an opportunity for you as the legal advisors to really play an active role in figuring out who's the best mediator for this particular matter. Our understanding about your practice is that often the mediator is, at least in court cases, it's assigned by the judge, but that the judges do take input from you if you wish to give it. And that's a real opportunity, not just to accept whoever the judge says, but be able to tell the judge, to suggest to the judge, if you can reach agreement with your opponent, that we think that the following person or persons might be good. for this particular case. So it's a real opportunity for you to match the mediator to the case.
And we were told by the judges that if the lawyers come in and say, we request this mediator, then the judges will refer to that mediator.
Likely in any event. They're not an absolute guarantee, but certainly that's right. And in our practice, it's actually not uncommon for the representatives of the parties to do a fair amount of investigation. There are, ask other people in their law firms and at other firms what their experiences are. And it's even the practice that sometimes I will be interviewed as a prospective mediator. The lawyers will want to talk with me first before they're prepared to hire me when they're hiring me privately as a mediator. So that's another thing for you to consider about how you're going to go about that process and how active you can be in matching the mediator to the case.
So one of the things that I implemented while being a litigator is I made it a practice to try and learn a lot about the potential mediators in advance, because your role in selecting a mediator, the proper mediator for your client, is a critical role that you play. If you end up, for example, picking a mediator, and I'll use these terms, although there's a lot of controversy about how descriptive they really are. But let's say you have a client that is very strong-minded, and needs a mediator that is very strong in expressing direction and opinion, is willing to engage in what I call the evaluative side, to speak candidly in private caucus about what the strengths and weaknesses of a case are. And your judgment is that's going to be helpful bringing your client to a better understanding. There's an expression we say, you can't be a prophet in your own house. You probably have in Poland a similar expression, that you can have the absolute truth that you're telling to a client, but you need somebody on the outside to credibly present it. Well, oftentimes a mediator can play that role and bring a challenging or difficult client to a better place in terms of reaching a resolution. And in my practice, where I did not know a proposed mediator, I not only called about the reputation of the mediator generally, I called other firms of both sides, both plaintiffs and defense firms that I had developed a collegial relationship. And I asked, when they used, and they can talk about this without breaching confidentiality, what was your experience with that mediator? And that was so helpful to me, really, really helpful in making sure the right selection was there. And what a difference it made between going in blind. It was just enormously important. So I would encourage you to keep that kind of approach in mind so that you fulfill professionally and conscientiously truly your unique role as a legal advisor to direct your client in the proper way.
Exactly. So let's take a break. And then there's a little bit more on this, and then we'll open it up to questions.
Is that okay? Good time for break?
Great.
Okay. And how long is our break? Roughly 15 minutes.
So we'll
Great.
see you back in 15 minutes.
1-5, not 5-0. 1-5.
Great.
Are we muted out now? Can we?